Welcome to the deep dive. Today, we're jumping into a really tricky spot in contract law. It's about a difference between a contract condition and a simple promise.
Right, and this distinction can mean millions of dollars, especially in big construction projects.
Exactly. We're looking at who picks up the tab when, say, a project owner suddenly goes bankrupt. Is it the general contractor or the subcontractor?
That's the question. And it often hangs on these things called pay-when-paid clauses. On the surface, they sound straightforward. I'll pay you when I get paid.
But it's not always that simple, is it?
Not at all. Because the legal fight becomes, was that just about timing? Or was it an absolute requirement, a condition meaning if the owner never pays the contractor never has to pay the subcontractor?
So our goal here is to really dissect how the law tells these two apart. How do courts figure out if a clause is just setting a schedule or if it's actually building a wall that blocks payment completely?
To get there, we first need to nail down the basic legal rule courts use when they look at these clauses, especially when they're a bit ambiguous.
Okay.
Then we'll walk through, step by step, the really strict test the court laid out in a major case from 1962, Thos J. Dyer Co. e. Bishop International Engineering Co. That case really set the stage for how risk works in these situations.
All right, let's start with those basics then. What really is the difference in how the law treats a condition versus a promise? And why do courts seem, well, reluctant to call something a condition?
Okay, so a promise is basically a guarantee. If you make a promise in a contract and don't keep it, that's a breach. You might owe damages, but the underlying duty, like the duty to eventually pay, usually still exists.
Right.
A condition, though, is different. It's an event, something that has to happen before the other party's duty kicks in. So in our payment example, if getting paid by the owner is a true condition.
Then the owner goes bust.
Exactly. If that event, the owner paying, never happens, then the general contractor's duty to pay the subcontractor just evaporates. It never even arose.
Wow, okay. So the subcontractor does all the work, finishes the job, but because of this condition failing, they get nothing. That sounds incredibly harsh.
It is. It's what the law calls forfeiture. The subcontractor loses their right to payment because the condition wasn't met. And because forfeiture is such a severe outcome, courts really don't like it.
So they lean the other way.
They absolutely do. There's a very strong judicial tendency built up over a long time to avoid interpreting contract language as creating a condition unless the wording is just overwhelmingly clear, like unavoidable.
So the default setting, if you will, is that linking payment to a third party, like the owner paying, is probably just about when the payment happens, not if it happens.
That's precisely it. You see this stated in lots of cases, including the Dyer case we're about to discuss.
Yeah.
Unless the contract spells it out in flashing lights, courts will say the clause just sets the time for payment.
And if that trigger event, the owner paying, never happens.
Then the general contractor still has to pay the subcontractor. They just have to do it within a reasonable time.
Okay, hold on. That's a critical point. So the general contractor is the one stuck with the loss from the owner's bankruptcy, right? They can't just automatically pass that risk down the chain unless the contract explicitly says so.
Correct. The default is that the GC bears the owner's credit risk. So how did this actually work out in the Dyer case?
All right, let's analyze Thos J. Dyer Company v. Bishop International Engineering Company. First, what are the legally dispositive facts? What do we need to know happened?
Okay. Dyer was the plumbing subcontractor. Bishop was the general contractor. The project was building the Latonia racetrack in Kentucky. Dyer did all their work, finished everything. The value was significant, over $108,000 back then.
That's a lot of money, especially in 1962.
Definitely. But here's the problem. Before Bishop got paid that specific amount by the track owner, the Jockey Club went into bankruptcy, Chapter X proceedings.
So the money stream stopped.
It stopped. And Bishop then refused to pay Dyer the $108,000, pointing straight at paragraph 3 in their subcontract agreement.
Okay, and what was the crucial language in paragraph 3?
It said, and this is the key part, that no payment shall be due until 5 days after owner shall have paid contractor therefore. Bishop basically said, look, the owner hasn't paid us, so under this clause, we don't owe you yet. Maybe never.
Got it. So the core legal issue for the court was, did that simple sentence create an absolute condition? Did it mean Bishop only had to pay Dyer if and only if the Jockey Club paid first, thereby pushing the bankruptcy risk onto Dyer? Or was it just setting a reasonable time frame for Bishop to pay Dyer?
That was the entire fight. And to figure it out, the court leaned on that interpretive rule we just talked about. The presumption is that this kind of language is about timing payment, not shifting the fundamental risk of the owner going broke.
Right.
To overcome that presumption, the contract needs an express condition clearly showing that shifting the risk was the intention of the parties.
Okay, let's break that rule down. It sounds like a tough standard for the general contractor bishop to meet. What are the specific elements the court uses in this interpretive test?
The court essentially set up a two-part test to see if the presumption against forfeiture could be overcome. First, clear expression of intent. The contract language has to be really unambiguous. It needs unequivocal terms or an express condition that clearly shows the parties meant to move the usual credit risk from the GC to the sub.
Unequivocal terms. Got it. What's the second element?
Second, consistency with normal intent. The interpretation has to make sense in the real world of construction. It needs to align with the sort of fundamental concept of who normally takes on the risk that the owner might not be able to pay.
Okay, clear expression and consistency with normal business practice, thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, clear expression of intent, to that paragraph 3? Did it have those unequivocal terms?
The court said no, not even close. It found that paragraph 3 was pretty plain vanilla. It just talked about the amount of payment and the timing 5 days after the owner pays.
But it didn't explicitly talk about risk.
That was the crucial missing piece. The court stressed that the clause did not mention the possible insolvency of the owner. There were no words like risk, insolvency, condition precedent, or anything that dealt directly with the disaster scenario the owner failing to pay at all. Without those specific, unequivocal terms, the court found the language just wasn't strong enough to create an express condition and shift that credit risk to Dyer.
That's really interesting. So just saying pay when paid isn't enough. You almost have to say pay only if paid, even if the owner goes bankrupt and subcontractor, you accept that risk.
Essentially, yes. The language needs to explicitly address the risk of non-payment, not just the timing of payment in the normal course of things.
Understood. Okay, now what about the second element? Consistency with normal intent. How did the court analyze the typical understanding of risk in construction? Who usually bears the risk of the owner?
The court laid out the standard business reality. Bishop, the general contractor, was the one who contracted with the owner, the Jockey Club. So Bishop was the one who took on the risk of whether the Jockey Club was financially sound. That's the GC's typical risk.
Right, the GC picks the owner.
Exactly. Dyer, the subcontractor, on the other hand, contracted with Bishop. Dyer looked to Bishop for payment, not the owner. To flip that around, to force Dyer to bear the risk of the owner's solvency, the contract would need a very clear, deliberate statement saying so.
And interpreting paragraph 3 as a condition would do that flip.
It would, and the court said interpreting it that way, meaning Dyer might never get paid for $108,000 worth of completed work simply because the owner went bankrupt, was an unreasonable construction. It just didn't align with what parties normally intend. Why would a sub agree to that kind of forfeiture without very explicit language?
So basically, if the interpretation leads to what seems like a wildly unfair result, like the sub working for free because of someone else's bankruptcy, the court will prefer the interpretation that avoids that forfeiture.
Precisely. The court concluded the clause was only meant to give Bishop a reasonable window of time to get the money from the owner, not to excuse payment altogether if the owner failed.
And after analyzing both elements, finding no clear expression of risk shifting, and finding that a condition interpretation would be inconsistent with normal intent, what was the court's final conclusion?
The court upheld the judgment in favor of Dyer, the subcontractor. It ruled that paragraph 3 was not an absolute condition precedent. It merely fixed a reasonable time for Bishop to pay.
And since the work was done and the owner was bankrupt,
a reasonable time had clearly passed. Bishop was therefore liable for the full $108,519.11 plus interest. The case firmly established that unless the contract explicitly says otherwise in unequivocal terms, the general contractor holds the bag for the owner's insolvency risk.
Okay, the message seems clear. If you want to shift risk, you need to shout it from the rooftops in the contract. Specificity is key. To make sure everyone listening really gets the difference, let's try a really stark contrast. Imagine a huge, messy job, maybe cleaning up a toxic waste site. Super complex, high stakes. Hypo A. The Dyer clause. The subcontract for the cleanup crews says, subcontractor will be paid for completed milestones, no part of which shall be due until 5 days after the state environmental agency pays the general contractor for that milestone. Then, the state agency goes totally bankrupt, dissolved, no money left.
Right. Classic pay when paid setup.
Now compare that to hypo B, the clear condition. This subcontract says, The general contractor's duty to pay the subcontractor is an express condition precedent. Payment is contingent upon, and only to the extent of, funds actually received by the general contractor from the state environmental agency for the subcontractor's work. Subcontractor expressly assumes the full risk of state agency insolvency or non-payment for any reason.
Wow, okay, that second one is definitely more aggressive.
It is. So, applying that two-part Dyer test we just discussed, clear expression and normal intent, how does the outcome change between Hypo A and Hypo B? Who eats the loss from the bankrupt state agency?
Okay, Hypo A is pretty much Dyer revisited. That clause fails the test. It talks about timing until 5 days after, but it's silent on the risk of the agency going broke. There are no unequivocal terms about assuming insolvency risk.
So, under Dyer.
It's interpreted as a timing clause. The state agency's bankruptcy means a reasonable time has passed. The general contractor has to pay the subcontractor for the work they did, even though the GC never got paid by the agency. The GC absorbs the loss.
Okay, so the sub gets paid in Hypo A. Now, Hypo B.
Hypo B is completely different. That language hits both elements of the Dyer test head-on. It uses the magic words, express condition precedent, contingent upon, only to the extent of funds actually received. And crucially, it explicitly states the subcontractor expressly assumes the full risk of state agency insolvency.
It directly addresses the disaster scenario.
Exactly. That is the unequivocal term dealing with insolvency that was missing in Dyer and Hypo A. Here, the parties have clearly, unambiguously, and deliberately shifted the normal credit risk.
So the outcome in Hypo B.
The outcome is forfeiture for the sub. Because receiving funds from the agency was made an express condition, and that condition failed due to bankruptcy, the GC's duty to pay the sub never arose. The sub gets nothing for their work on that milestone. The risk was successfully transferred.
That starkly shows the power of specific wording. The difference between getting paid and getting nothing hinges on whether you explicitly address the risk of the money source drying up.
Absolutely. And for anyone listening, whether you're drafting contracts, managing projects, or, facing a law school exam, the Dyer case gives us a really practical checklist, a diagnostic tool for analyzing these pay-when-paid situations.
Okay, let's lay out that checklist. What are the steps?
Step 1, identify the clause type. Are we looking at a clause that links the GC's duty to pay the sub to some action by a third party, usually the owner paying the GC? If yes, proceed. Simple enough. Step 2.
Step 2, test for express condition and risk shift. This is the core Dyer test. Does the clause use those unequivocal terms? Does it specifically mention the risk of insolvency or non-payment by the owner or third party? Does it use language like condition precedent or sub assumes the risk?
And if the answer is no, if it just says something simple like payment due 5 days after owner pays,
then you go to step 3, apply the judicial preference. If that clear, unequivocal risk-shifting language isn't there, the default rule kicks in. Courts will treat the clause as a promise about timing only. It sets a reasonable time for the GC to pay. It doesn't excuse payment altogether. The GC can't use the owner's non-payment to avoid paying the sub indefinitely.
Okay, and the final step.
Step 4, confirm the default risk allocation. Just remember the baseline. Unless the contract uses that super clear, explicit language to change it, the GC bears the risk of the owner's ability to pay. The sub bears the risk of the GC's ability to pay. That's the standard setup. Don't let ambiguous language overturn it. It really is fascinating. The law basically says, we assume you expect to get paid for work you finished. That assumption is so strong that you need incredibly precise language, almost like a legal sledgehammer, to overcome it. Silence or just hinting at it won't cut it when the result is forfeiture.
Well put. The default protects the party that performed the work.
Now, this whole discussion centered on the owner's bankruptcy risk being pushed down from the GC. But it makes me wonder, let me leave you with this thought. What if the contract didn't mention the owner at all? What if it said something like, payment to the subcontractor is not due until the general contractor secures sufficient operating capital for the fiscal year?
Interesting twist.
Is the GC's own financial success, their internal capital, considered a valid external condition that could excuse paying the sub? Or is ensuring their own funding always just part of the GC's basic promise to manage their business and pay their bills? Where's the line? Something for you to think about as you review these cases.
That's a great question. It really pushes on the definition of what constitutes an event versus just the contractor's own ability to perform. Definitely food for thought.
Thank you for joining us for this deep dive into the critical difference between conditions and promises. Make sure you review those key elements from the Thos Dyer candidate test. They are crucial. Until next time.